Except in the case of a split, a legislature has to support his party willy-nilly. This is the difference between the position obtained prior to and after the 10th schedule. Prior to the said amendment, a legislature could shift his loyalty from one party to the other and any number of times without imperiling his membership of the House. It was if he had a property in the office.
So here they say, actually, Bomai deals with a completely different situation. Bomai was a case where the Council of Ministers had offered to summon the House, the session of the Legislative Assembly within a period of 1 week. Governor says, so sorry, I'm convinced that you have lost the confidence of the House. Therefore, you send the report to the President under Article 356. There the court holds that this course was not open to the governor. The only way to establish whether they had lost the majority of the assembly was to order a floor test. And therefore, the governor couldn't, on his own personal opinion that they had lost the majority, say that, well, I'm going to send a report to the President under 356.
So,
second, they also make it clear that with the introduction of the 10th schedule, unless it's a case of a split, which was a position prior to the deletion of the split in 2004, the only case where you can not vote for your own party is a split. Otherwise, you're bound by the coattails of the party which is
no difficulty.
So now, post 2004, with the split having gone away as a defense,
yes,
the only other available exception is the case of a merger.
Right.
Save and except in the case of a merger, you are bound to vote for the party.
Right. No difficulty. But my lord, there's two things. Firstly, no doubt, as the facts, my lord, the Chief Justice summed up of Bomai. But Bomai doesn't just restrict itself to those facts. What Bomai says is the moment a support to a ministry is withdrawn, the fact is that in that case, the Chief Minister was keen to face a floor test. The governor dissolved the House and sent a report to the President. But what para 119 says is the moment a support to a ministry is withdrawn, the only option left to the governor is to conduct a floor test.
If we accept this extreme proposition, very radical results will result. On the one hand, you have the 10th schedule, which is to prevent, the constitutional sin of defections. On the one hand, you say that, well, somebody who defects or causes a split is liable to a disqualification. At the same time, we say that, look, even if that person is liable to be disqualified, in the meantime, you must hold a trust vote on the floor of the House. That is why, if the antecedent reason for a floor test is based on a violation of the prescription in the 10th schedule, then holding a floor test at that stage will defeat the whole basis and purpose of the 10th schedule then.
No, Manoj, may I with respect say, when your lodges firstly...
And you are legitimizing then a defection which is otherwise not permissible under the 10th schedule. That's what is happening actually.
Firstly, our case is not a case of a split at all. I am not relying on any defense at all. I am neither relying on 3, which in any case does not exist, or on merger. That's not been my case. I've right through argued that we are talking about a rival faction within the party, which is dissent and a sense of democracy within a party, and we claim that we are the Shiv Sena. And that is what comes to be decided. I'm not for a minute either relying on the defense or merger or on the split of 1/3. That's their contention. My case has never been.
But whether you are the Shiv Sena or not, can't be decided on the floor of the...
Will be decided. Of course not. Your lodges are right. Who is the political party will be decided by the Election Commission of India. And that power is vested in the ECI. And your lodges in judgment after judgment from Sadiq Ali downward that said that the exclusive jurisdiction, and there's a presumption of validity as far as decisions of the ECI are concerned. I come to those decisions.
On the 30th of June, there was no decision of the ECI.
No, my lords. On 30th, there was no decision of the ECI for the simple reason that if the decision will come when someone raises that issue, it will only be when a party approaches the ECI. There can't be a decision of the ECI devotes a party approaching the ECI.
Mr. Kaul,
the ECI...
No, where is the question of the party approaching the ECI? For our understanding, on 30th, there was only one party. You were part of the party?
Yes.
Whether there was a faction within or without, you contested the election on the strength of a ticket given by the party, which was the original party. then
And I still say I'm the original party. They are the overwhelming minority.
to say it. You are, as we understand, to show it within the party on the
Yes,
basis
and absolutely right. My lady is right.
do it in the house.
No. I'm not saying I do it in the house. That's why I'm saying floor test and majority in a political party are completely different
When
issues.
you go back to the party members to say, okay, here is a faction that we think are actually the Shiv Sena. So we are going to the party as in not just the organization, but each one who counts in the party that makes the party to say, now we are.
So let me answer that. Let me answer that. One is which is the rival faction within the party who should be recognized as the party under the symbols order. That's what the symbol order provides for. That can only be decided by the election commission and no one else who represents the party and is the recognized, which faction is the recognized political party. That's one part. In the meantime, a ministry which has lost the confidence of the House cannot continue is a completely different issue for which the floor test is meant. I'm not going for a floor test in this matter to show that I'm the majority in the Shiv Sena political party. That has never been my case. Has never been my case at all. I'm going to the floor of the House to show that you, Mr. Thackeray, and the NDA government, coalition government that you lead has lost the majority because 7 independent MLAs and 34 of the 55 MLAs have no faith in you. Now they are presuming that this is only a rival faction within the legislature party and not a rival faction within the political party. Whereas your lodges have time and again said you can't segregate the two. A legislature party is also an extension of the political party. In fact, for the continued recognition of a political party, the legislative presence of its MLAs and the percentage of vote it polls is a necessary ingredient for continuing recognition. Under 6A and 6B of the symbols order, and Sadiq Ali took note of it, they said for a party's continued recognition as a political party, its performance in the electoral hustings, its vote percentage, its MLAs and MPs are equally important. These are their arguments. And that is what I've been saying. You yourself, you're the judge, you're the jury, you say, per se disqualified, there was a split only in the legislature party, and thus nothing else needs to be done. My whole case has been, it's a case of internal dissent. We are the faction which represents the Shiv Sena. That issue can only be decided by the election commission, where your lodges refused to stay those proceedings. The same argument was made. As far as the floor test is concerned, it is only restricted to the issue whether the chief minister or the ministry has the confidence of the House or not. And what does the governor do? The governor says, comes and face a floor test and you resign. Now, that was a pertinent question that day, which was put by your lodges and my lord, the Chief Justice, saying that had this chief minister not resigned, one could have possibly seen what is the effect of those 39 plus 4 votes or 3 votes. Now, 2 answers to that. You remove those 39 plus 3 or 4, 42 votes. We are still through by a mile. And I prepared those charts and I'll show. You remove each of those 39 plus 3 votes, whose 42 in all, whose disqualification was pending, we were still through. In that case, that's one. Secondly, my lords, my first contention would still be, why should those 42 be deleted at all? Because let's face it, on that day, Nabam held the field. If Nabam held the field, Nabam said that as far as the speaker is concerned, he should not proceed with his with disqualification till its own case is decided. But let's take it. Let's take it, they should have been excluded. A chief minister who does not go through even with the deletion of 39 plus 3 or 39 plus 4, both for the election of the speaker and the election of the chief minister. He fails in both cases. I prepared those charts with 42, without 42. Because as your lodges rightly said, with those 42 votes, then the total strength also comes down.
देश विदेशातील प्रत्येक घडामोडींचे लाईव्ह अपडेट मिळवण्यासाठी आता साम टीव्हीच्या सर्व सोशल मीडिया प्लॅटफॉर्मला लाईक, फॉलो आणि सबस्क्राईब करा. तसंच सर्व नोटिफिकेशनसाठी बेल आयकॉन प्रेस करायला विसरू नका.